Hello and welcome to Contract Law 101 Part 3. In this video I'll explain the fundamentals that are required to that formulates a contract and makes it legally valid and binding. They're also known as key requirements. There are 7 of them, which are the 7 key requirements that I educated myself in 10 years ago, and I've noticed recently, depending upon where you look or who defines what the key requirements are, I've noticed that some of it has gone down to 6 or maybe 5 key requirements, which gives me the impression to believe that what they've actually done is amalgamated a couple of key requirements together to either deceive a little bit or just to simply make the key requirements a bit smaller. I think there's anything else I need to say about that. So with no more further ado, first and foremost, I am not a legal representative and therefore cannot provide legal counsel. This video, its predecessors and any successors, if there is any, are purely tutorial educational purposes only. Anything you take from these videos in an attempt to apply to a situation you may be facing, you do so at your own risk, as I will not accept and cannot accept liability or responsibility if the outcome is detrimental to yourself. And having said that, let's proceed. 7 key requirements that are required as a foundation stone to making a contract legally valid and binding. And these are in no specific order. Key requirement number 1, signature. A signature must be obtained voluntarily. It cannot be obtained by coercion, force, intimidation, blackmail, duress. It has to be obtained by voluntary willingness to do it. And also, anybody else, any other alleged parties who are going to engage in the contract, they must also, as well as yourself, initial and sign every page. Okay, that's, for lack of better words, clarity reasons. There can't be any hidden or silent people involved in the contract. It's clear, open, everybody knows who is an alleged party to the contract. So that's that. The second one is full disclosure. It's pretty self-explanatory, but I'll explain it anyway. Full disclosure is that the complete and utter, without a doubt, across the board, every little nook and cranny involved in the contract must be fully disclosed. In other words, there can't be a contract and then all of a sudden there's been an additive made to it after the contract has been signed or after some period of time. It must be inserted into the contract format at or prior to signing. So that's what full disclosure is. No additives, no exits. Little additives or removals can happen, but the process for that to happen is that every alleged party must be notified about it, and then every alleged party must then agree or disagree. If you picture it like a trial jury, the jury of 12 goes into a room to vote in favour of or non in favour of, so it has to be a unanimous decision, so to speak. Alright, meeting of the minds. I kind of jumped ahead of myself with what I just said. Meeting of the minds is where every party in the alleged contract all see eye to eye, they're all on the same page. This is the whole 12 jury thing. It has to be unanimous, and once there is a unanimous decision and everybody agrees, everybody's on the same page, then it can proceed to the next key requirement. So that's what meeting of the minds means, seeing eye to eye with people or other parties. Intent. Intent is a lot like desire. If you desire somebody, your intention is to go after that person. It's exactly the same in contract law. you have to have the intent to want to engage in contract. Okay. I don't think there's an area of where initially your intent was to engage in contract, but then you backed out, because the reality of it is, prior to signing, if you backed out, then nothing comes of it. So intent is your absolute assertion that you want to do this. Equal contribution. Now, equal contribution is where everybody, all the alleged parties, have to equally contribute to the contract. Nobody can say, oh, well, I'll give you 2 spuds if you give me 1 spud, for an example. Okay, everybody must all participate with an equal contribution to the alleged contract. Okay, if that isn't there, contract's null and void. If the meeting of the minds isn't there, contract is null and void. If full disclosure isn't there, it's null and void. Same with signature. Number 6 is capacity, and the capacity is that you have the sound mind. All parties have the sound mind, which is capacity to engage in contract. Not to be cruel or unkind, but as an example for absolute clarity, an entity that suffers from Down syndrome does not have the capacity to comprehend what the contract is about or how it goes about, what's involved. Okay, so that's capacity of sound mind to engage in contract. Offer and acceptance. Offer and acceptance is, funny enough, what I said before. Offer 2 spuds for 4 carats. Now I know the numbers are odd, but that's the offer. And if the person with 4 carats says, yeah, okay, I've got plenty of carrots, but I don't have any potatoes, so yeah, I'll accept that. I guess in a sideways step, you could say equal contribution. In the same scenario of 2 potatoes over 4 carrots, it could be between 2 people agreed to that is a equal acceptance or an equal contribution, on the basis that, as I said, the carrot grower has plenty of carrots but no potatoes. The potato grower has plenty of potatoes but no carrots. So there can be a negotiation within that scenario. But offer and acceptance, as I said, the potato grower offers the carrot grower 2 potatoes for 4 carrots. Okay, that's what I'm offering you something, you accept my offer. And every alleged party in the alleged contract has to be on, again, the same page. Everybody has to agree to it. So everybody has to equally contribute and can negotiate amongst the other alleged parties. And if everybody agrees, there's the meeting of the minds, and there is also the offer and acceptance, which is probably one of the ones that they've shortened down, because it kind of refers to 2 different keys but means the same or similar outcome. So that's the key requirements. I suggest you write those down, and I also suggest that you recite them to the point of where they become embedded in your memory, so that you can just absolutely run with it off the tip of your lips, as opposed to have to sit there and think about it. And I also suggest the same for the other words that I suggested you write down and memorize in part 1 and part 2. The other side of it is that if you do that and you become proficient in it, if somebody's challenging you, you can just go blah 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 like that, and you look or sound professional because you can recite it like it's a second language. And that's the point of it, is to give the perception to the person you're speaking to that you're not an idiot, you know what you're talking about. So the key requirements primarily pertains to paper warfare document contract. Okay, if you find in any contract that you're expected to sign or you're prepared to engage in, you obviously look through it and read every word, because remember, every time you sign your John Doe to something, you're attesting that every word on that piece of paper or that entire document, no matter how many pages, that it is true, complete, concise, and not misleading. So you read everything, and if you have to read it twice, read it twice. And if the other people or the other parties are getting the shits with you, screw them, because at the end of the day, you're putting your John Doe down as this being absolutely fulfilled, complete, and true. And if it's not because you perceive that you read something that your eyes read but you didn't read, if that makes a lot of sense. People skim over a document or a letter, and their eyes think they read something, but it's not what was actually there. I actually did that to myself once over a search warrant. The reason I made that mistake is because I was more infuriated that the police were issuing me with a search warrant. And instead of thinking clearly, I went off my nut about it, being offended, and I didn't actually read it properly. I skimmed over it to see what it was all about. But that's another story. So that's where it is. Read everything thoroughly. Do not make assumptions that's what you thought you read. Read it thoroughly. That is most important. Now, how do people engage in contract law every day in the great big yonder of public arena? Well, we'll use Starbucks as an example. So let's say you go to Starbucks, you want a cappuccino. Okay, it's fair enough, most people drink coffee. It doesn't have to be Starbucks, it can be any place that sells coffee, but we're just using Starbucks for a name for the purpose of this explanation. You go to Starbucks, you walk in, young lass behind the counter greets you, as they do because you're a customer. She asks how she can help you, and you say, I'd like a cappuccino, please. All right? And the young lass says, okay, not a problem. Do you want sugar with that? Do you want any specific type of milk? No, just a straightforward cappuccino, no sugar, whatever milk, doesn't matter. Okay, sir, thank you. That will be $5.50. Now, that is a part of contract law, offer and acceptance. You've requested to have a coffee made. She's accepted your request and accepted that, and you now have to make the decision as to whether you're going to pay the $5.50. So there's offer and acceptance in a reverse scenario, but it's still the same concept of contract law. Okay, so she marks down your name on the cup, and what is it? It's cappuccino, standard milk, no sugar, all the rest of it. Flings that off down to the bloody barista. Barista goes ahead and makes it. You're standing there quite patiently waiting for your cappuccino, and your name's called out. You go and pick up your cappuccino. You take a quick sip, and because it was a quick sip, your taste buds didn't really get a taste for it. Tasted a little bit like a cappuccino, but that's just the first initial, this is what my taste buds tell me. You walk outside, take a big gulp, and you go, tastes like gutter water, for whatever reason. Okay, so you decide to walk back into Starbucks and complain to the young lass behind the counter. Now, 9 times out of 10, Starbucks wants you to come back, buy more coffee. So they will generally replace your coffee for you free of charge. However, if the young lass behind the counter is a bit of a smart cookie and has done a bit of research and educated herself, she would recognise that what she's engaging in is contract law. Now, she can sit there and recite if she wanted to, well, I apologise that you don't like the taste of your coffee. However, you ordered a cappuccino, not a nice tasting cappuccino. And I know that sounds nitpicky, but that's how stupid it is. Okay? Where the failure on your behalf was, you failed in full disclosure of the verbal contract in that you wanted a nice tasting cappuccino, not just a cappuccino. Right? And so the young lass who's a smart cookie can sit there and say, well, you ordered a cappuccino, not a nice cappuccino. But they won't do that. Why? Because they want you to come back, buy more coffee, so they'll just replace it. Not a problem. But they're little examples of what can happen. The same thing happens at a service station. This is the irony about... No, I won't go there just yet because I'll leave that for a next video for a better explanation. Because otherwise this video is going to take forever in explanations. But that's pretty much where it's at. There is contract law across the country without fail. As a quick explanation as to how can I prove this. Okay. There is 5 tiers in proving that this entire country runs on contract law. The first tier is this thing we call money. Okay, that's the first step. And from money comes commerce. Now, commerce is a fiscal calculation, if you like. So we've got money. Next step is commerce. The next step after that is trade. You trade money for goods. Okay, you go to Hardly Normal and you want to buy a TV, they're happy to sell you a TV, providing you have the money. You have the money, they'll take your money and they will give you a TV. That's trade. Okay, now from trade, in tier number 4, is a thing called Bills of Exchange Act. Okay, now the initial Bills of Exchange Act dates back to 1909. Much the same as maritime law, where some words have two meanings, Bills of Exchange Act, just in the wording, decrees that it has two meanings. A bill can be money, or a bill can be a written letter of demand. Okay? So don't get yourself confused by that. When you see money, you're looking at the bill as in money. When you're looking at a letter of demand, that is a bill. Now, there's a thing in Bills of Exchange Act 1909, not that it's any relevance, but just for, shits and giggles sake. If you lived in a state and received a bill where that bill originated from another state, under the Bills of Exchange Act 1909, that's called a foreign bill, a foreign implement. And under the jurisdiction of the 1909 Bills of Exchange Act, you don't have to pay it because it didn't originate from your place of residence, i.e. your state that you live in or reside in. Okay, I wouldn't want to go and push it, but if push come to shove where somebody was pushing you and you were shoving back and they pushed harder, you could actually cite that particular act within the act. So we've got trade, we've got money, commerce, trade, Bills of Exchange Act 1909, and the last but not least is contract law. And the odd thing about, or the beauty about, tier 4 and tier 5 is they both mutually uphold each other. In other words, you can't have one without the other. Okay? Because Bills of Exchange Act also covers contractual terms agreements. Okay, so it's got to be there. And you can't have contract law without an act that governs the necessities of formulating a contract. Okay, hence foreign bill. So there's the 5 tiers that proves this entire country operates on contract law, all because of the very first tier, which is money. If we didn't use money, which, as you know, they're trying to get rid of it furiously by going over to a digital sense, if they succeed in doing that, then they get to rewrite the whole key requirements to formulating a contract. All that goes out the window. Why? Because they no longer operate on money, cash. There is still commerce, but it's in a digital sense, not a cash sense. There is still trade, even though, because it's a digital sense. They can ignore 1909 because it's a digital sense. That means they can remove contract law. But the thing is, they're going to have an uphill battle trying to do that, because the simplicity is this. All governments across the nation of Australia, states and territories and federal, are all registered businesses. The Australian federal government is registered as a business in Washington, DC, and the word Australian federal government is just a trading name. I don't know what their legitimate company name is, but AFG is just purely a trading name. And the reason I can say that, even though I've yet to find out what it is, I know for a fact that the Queensland state government is also registered in Washington, DC as a company, and the term Queensland state government is just a trading name because there was a court case, I can't recall what year it was, but the deliberation on the matter was that all property, inclusive of people, are property of the Brigalow Corporation. Now, Brigalow is a tree primarily found in Queensland. Kind of makes sense. So the Brigalow Corporation is registered as a company in Washington DC, trading as Queensland State Government. So they're a corporation, business, company. What do people formulate companies for? To make money. Now, when you take that into consideration and revert it back to or apply it to part 2 video, everything starts to make sense of how you got turned into a corporation, because they can only control what they created and they want to control you, so they had to turn you into a corporation, right? Because they're a corporation themselves. If they didn't turn you into a corporation and told you to jump, you could turn around and say, well, you jump and jump on that. I'm not going to do it. But because they turned us into corporations and chose not to tell us about it because it's a fraud, it's a scam, it's illegal, they don't want you to know that, because then they've got no power over you, okay? But because people don't know that, people eagerly bend over and comply because they think that the government has the right to do it. People seem to lose their mind in acknowledgement that you vote these people in. They are legitimately supposed to work for you, but they don't. They work for themselves or their master. So they tell you what to do, they take all your money, make your life bloody miserable and near impossible to live, because they're serving the agenda of somebody else. So that's pretty much where, and the whole contract law thing applies to every business in this country, which means every government subdepartment, police station or police service nationwide, doesn't matter whether it's AFP or whether it's a state police service, every council, every fire department, every ambulance, every hospital, they're all corporations. The courts. Now the thing about a corporation is this, and I'll use the courts as an example. In order to trade in commerce, plus the ATO is a corporation, allegedly. I'll explain that in the next video. When you have a corporation, and the word corporation in Latin, I think I discussed this in video 2, but if not, I'll do it now. You break the word up, and in Latin, it's corp oration. So you got corp / oration. In Latin means dead man talking, and I have mentioned this in video 2, so I won't go any further. But here's the thing. Because it's a registered business, and it has to be a registered business because A, it's dealing in money, and B, it's operating commerce, and C, it's trading. Okay? Where there's an exchange of money between one party and another party, that's a trade, and if it's involving money, that's commerce, and primarily money. So all government departments usually want money out of you, so they've got to be registered to do that. From the Australian federal government down across the board, picture it like a pyramid effect. The Australian federal government is the parent corporate company of Australia, okay? And they govern all the other corporations or registered businesses or companies. And a company has no substance. What is a company? It's just a name. It has no substance. It might have validity, but it has no substance, because it's the people that work in the company that create the company to make it a company. Okay? So therefore, the ABN of a registered company extends itself to all employees, representatives, and agents of the company. And this is why if you get served a summons, either by police or a bailiff, he's operating under, we'll say a bailiff, he's operating under the court's ABN. Okay? So that means that the magistrate is a representative of the court. The bailiff is a representative of the court. The person that types out everything that's said is a representative of the court. Prosecutions, even though it's Queensland Police Service, the prosecution's designated job is to prosecute on behalf of a police service, which is a registered business. This is how cops manage to infringe upon you with a penalty fine for speeding or something stupid like that, because they're trading in commerce, so they have to be a registered business. So that's some explanation on what formulates a paper warfare document contract, what's required for it to be legally valid and binding. If there's a technical glitch or a flaw in the contract and you don't pick it up immediately when you've signed, but you pick it up later because it was made apparent to you by something that whoever else is in the contract was trying to do to you or apply to you, and you go back over it and go, oh damn, didn't see that, or hey, that wasn't there before, then you can challenge it in court. As an example, elderly care nurses, right? One lass asked me about, or inquired with me about contract law, and the first thing I said to her was, well, are you a straight out employee or did you engage in an employer-employee negotiation? She said, yeah, well, pretty much most elderly care facilities are employer-employee negotiations. I said, right, so it's contract law 101, not a problem. I said, in your duration of your employ under that employee-employer negotiation, has your contract ever come up for review? And she said, no. I said, right, you've got an open and shut case in your favour, because she was being threatened with either take the COVID vaccine or don't come to work. Now, that's an additive to the contract that she already agreed to, the employer-employee negotiation. It's a contract, she signs it, so it is a legally binding, valid contract, but they've decided to add, you've got to be vaccinated to work here due to COVID. Well, they're now violating the terms and conditions of the contract, and they failed in their duty to disclose full disclosure. It's an afterwards additive. If they wanted her to be vaxxed, they should have written that up before she signed the contract. Now, the contract was 7 or 8 years old, but it doesn't matter because a contract can go for 50 years. We'll use a mortgage loan as an example. The duration of the loan is 25, 30 years, maybe even longer. They don't review it or renew it every year. It just goes from the point it starts till the point it's ended. And the same with this lass's employer-employee negotiation. The problem always comes down to it is that people have been so bestowed with fear of consequence that they don't want to challenge it because their mind already tells them you're going to lose, because the system's set up purposely for you to lose. But because people think that, they don't think rationally or logically and go, well, hang on a minute, I've got the proof here in paper. You know, people just revert straight to, oh, I'm going to lose, I don't want to do this, I don't want to rock the boat. Screw the boat. You've got rights like everybody else. You may as well. Somebody's going to screw you over unjustly. Fight it. Fight for it. It's your rights. Doesn't matter whether they view you wrong or not, and it's pretty hard for a magistrate to sit there and go, oh, no, you're wrong. Because you can sit there and say, but Your Honour, it's in the contract. There's nowhere in the contract that says I had to be vaccinated to do this job. And the contract has been signed, evidenced by all alleged parties in this alleged contract. What can the magistrate say? You can't say, oh, well, that doesn't make any difference. Absolutely, it makes difference. It's absolutely validly important, and they know it. So chances are they're not going to do that anyway, because if a magistrate was to try that and the plaintiff lost the case, then they can appeal the case, and that means the judge doesn't necessarily get in the shit, but the judge does get told, well, the magistrate does get told in no uncertain times, you screwed up, don't do it again. You see, because magistrates are appointed by the Law Society, and the Law Society is a bunch of assholes who took it upon themselves to make laws for human beings with no authority to do it. So, you know, this is why, I mean, it's one of the aspects of why people don't have to obey laws. That's one aspect of it. The other aspect of it is a constitutional fraud. Now, that's completely nothing to do with the purpose of these videos, so I'm not going to go into that. If anybody wants to know about the constitutional fraud, leave a message on the descriptions of these videos, and if I see a request there, then I'll consider to make a video based on it. But that's Contract Law 101 Part 3. It's simple, it's stupid, it's not in depth in trying to explain it, unlike what it was with maritime law, because that was the beginning and everything has to be explained with clarity so that people can figure out what's going on or how it came about, and the same with part 2. As it goes along, it gets a little bit easier because there's not as much explained detail required to explain it. So I hope that helps. The only thing that I've got left to explain as far as contract law is concerned is substantiating and explaining that I can actually factually prove this, because at the moment, for anybody's particular concern, they could say, well, this is just hearsay. What proof has he got? Well, obviously I'd have to explain that to say, well, this is what happened in my life and this is what I did and it worked. So there's going to be a part 4. There has to be. Otherwise people can just say, what a load of rhubarb. So yeah, I'll explain it in part 4, which whether I make it tonight and upload it or whether it's done over the next couple of days, part 4 is coming, because I can't within myself just say, oh well, it started from this and it's gotten to that and that's the end of it, take it or leave it. I'm not like that. I won't explain something unless I can factually back it up. So there is more coming. And probably what else I'll do is in 4, I'll explain the legality shortfall, if you like, pertaining to documents that you may receive from the government, like census, council threats, the electoral roll, and more precisely to the electoral roll, how you can get out of it. And I'll explain the little thing about the ATO that a lot of people aren't aware. If you were just to randomly say taxation is illegal, people would laugh at you and say you're a fruitcake. Why? Because they heavily believe that taxation is a valid thing, and it's not. It's a voluntary thing. And I'll explain how it comes about, and I'll also explain the 2 court cases what the deliberation was over those 2 cases. But I'll do that in the next one, because that all seems to tie in with what I've tried and tested and worked out for me. And the ATO, oddly enough, was one of those scenarios where they tried to with me and I them back. And I haven't heard from them since, and that was 10 years ago. But anyway, I'll leave that for part 4. Enjoy your night. Take care. Keep safe.